The certified letter arrived on a Tuesday morning, and I knew it was trouble the moment I saw the return address from Meadowbrook Estates, homeowners association, stamped across the envelope. I stood there in my driveway in Portland, Oregon, holding what would turn out to be the spark that ignited the biggest legal mess our quiet neighborhood had ever seen. My name is Yates Morrison, and I had just become the latest target of Patricia Hendricks, the HOA president who treated our community rules like they were handed down from Mount Sinai. I tore open the envelope right there, my morning coffee still steaming in my other hand. The letter was typed in that aggressive all-caps format that somehow made even polite requests feel like threats. According to Patricia, my front hedges were in violation of Section 7.3 of the HOA bylaws, which apparently stated that all hedges must be maintained at a height not exceeding 4 feet. Mine were pushing 7 feet, maybe closer to 8 in some spots, and I had exactly 14 days to trim them down or face daily fines of $100. The thing was, I had not planted those hedges. They had been there when I bought the house 3 years ago, towering and magnificent, with these distinctive silvery green leaves that caught the morning light in a way that made my whole front yard look magical. The previous owner, an elderly man named Walter Chen, had maintained them meticulously, and I had simply continued his care routine. They formed a natural privacy screen between my property and the street, and honestly, they were one of the main reasons I had fallen in love with the house in the first place. I walked back inside, already feeling my blood pressure rising. My girlfriend Sarah was in the kitchen, scrambling eggs while listening to the morning news on her phone. She looked up when she saw my expression. "Let me guess," she said. "Patricia, how did you know you have that look?" The one you get when someone is being unreasonable about something stupid. She turned off the stove and came over to read the letter over my shoulder. "Hedges. She is seriously coming after you for hedges. Apparently, they are too tall. I have 2 weeks to butcher them or start paying $100 a day in fines." Sarah shook her head. "You know what? I bet she is just mad because you would not vote for her son in that city council race. She has been looking for a reason to come after you since then." She was not wrong. 6 months ago, Patricia's son Brandon had run for a seat on the Portland City Council, and he had gone door to door in our neighborhood soliciting votes. When he showed up at my house, I had been polite but non-committal. I had done my research, and frankly, his positions on affordable housing and public transportation did not align with mine. Patricia had somehow found out I had voted for his opponent, and ever since then, I had noticed her driving past my house more slowly than necessary, always with this calculating look on her face. "I am not trimming those hedges," I said, surprising myself with how certain I sounded. "There has to be something I can do. They have been this height for decades. Walter told me they were special when I bought the house, something about them being planted by his grandfather in the 1930s. "Then fight it," Sarah said. "Request a hearing or whatever the HOA bylaws say you can do. You are not the type to just roll over when someone is being ridiculous." She was right about that too. I had moved to Portland from Seattle 5 years ago to take a job as an environmental consultant, and I had built my career on not backing down when I knew I was right. If Patricia thought I was going to grab some hedge trimmers and destroy nearly a century of growth just because she said so, she had severely underestimated me. I spent the rest of that morning reading through the HOA bylaws, a mind-numbing document that somehow stretched to 47 pages of single-spaced regulations about everything from mailbox colors to the acceptable breeds of dogs. Section 7.3 did indeed mention hedge height, but the wording was vague enough that I thought I might have an argument. It said hedges must be maintained at a reasonable height that does not obstruct sight lines or detract from the aesthetic harmony of the community. Nothing about a specific 4-foot limit. I drafted a response letter pointing out this discrepancy and requesting a formal hearing before the HOA board. I mentioned that my hedges had existed at their current height for decades without complaint, that they did not obstruct any sight lines since my property was on a corner lot with excellent visibility, and that they actually enhanced the aesthetic character of the neighborhood. I printed it, signed it, and drove it over to Patricia's house that same afternoon. She answered the door in her usual uniform of khaki capris and a pastel polo shirt, her blonde hair pulled back in a ponytail that was probably meant to make her look younger than her 50-something years. Her smile was tight and fake. "Yates, what a surprise," she said, though we both knew it was not a surprise at all. "I got your letter," I said, holding up my response. "I am formally requesting a hearing. The bylaw you cited does not actually specify the height limit you mentioned." Patricia's smile did not waver, but something cold flickered in her eyes. "The 4-foot limit is based on standard HOA practices and the board's interpretation of aesthetic harmony. But if you want to waste everyone's time with a hearing, that is certainly your right. I will schedule it for next month. Your letter gave me 14 days, I pointed out. So the hearing needs to happen before then, or you need to pause the countdown." "Fine," she said, snatching my letter from my hand. 3 weeks from today, 7 p.m. at the community center. Do not be late." She shut the door before I could respond. I walked back to my car feeling both vindicated and uneasy. I had won a small battle by forcing the hearing, but something about Patricia's confidence bothered me. She had agreed too easily, which meant she thought she had an airtight case. Over the next few days, I started researching everything I could about my hedges. I took detailed photos from every angle, measured their exact heights, and documented how they sat in relation to the property lines and sight triangles for the corner. I even looked up property records and found old survey photos from the 1930s that showed the hedges already well established. Walter Chen had been telling the truth about his grandfather planting them. That research led me down an unexpected path. I was looking through historical records at the Multnomah County Library when a reference librarian named Tom noticed what I was working on. "Those look like Griselinia littoralis," he said, peering at one of my photos. "New Zealand broadleaf. Pretty uncommon to see them that old and that large in Oregon. Where are these?" "My front yard," I said. "Why?" "Well, if they are as old as you say, they might be heritage plants. Oregon has some pretty specific protections for historically significant vegetation, especially in urban areas where native and heritage plantings are being lost to development." My heart started beating faster. "What kind of protections?" Tom pulled up something on his computer. "Here, look at this. ORS 215.700 to 215.780. Oregon Revised Statutes covering heritage trees and significant vegetation. If your hedges are over 75 years old and can be verified as part of the original landscape design for your property, they might qualify for heritage status. That would make them protected under state law." I left the library with printouts of the relevant statutes and a renewed sense of hope. If my hedges qualified as heritage plants, Patricia and her HOA did not have a leg to stand on. State law would trump HOA bylaws every single time. The next morning, I called the Oregon Department of Forestry and was eventually connected to a woman named Dr. Elena Martinez, who worked in their heritage tree program. I explained my situation, emailed her my photos and documentation, and waited anxiously for her response. It came 3 days later. Dr. Martinez called me on a Friday afternoon, and I could hear the excitement in her voice. Mr. Morrison, I have reviewed your documentation, and I am fairly certain your hedges qualify for heritage protection. The Gryslinia littorale specimens you have are extraordinarily rare for this region and age. Based on the historical photos and growth patterns, I estimate they are somewhere between 85 and 95 years old. I would like to send someone out to do a formal assessment if you are amenable. Yes, absolutely, I said, trying to keep my voice steady. How soon can you come? How about Monday? I can come myself. This is exactly the kind of heritage vegetation we are trying to document and protect in urban areas. We set an appointment for 10 in the morning. I immediately called Sarah to tell her the news, and then I did something I probably should not have done but could not resist. I sent an email to Patricia informing her that the hedges in question might be protected heritage plants under Oregon state law, and that I would be having them assessed by the Oregon Department of Forestry. I attached the relevant statutes for her review. Her response came within an hour. State law does not supersede private property agreements. The HOA covenants you signed when you purchased your home give the board authority over landscaping matters. Your hearing is still scheduled for 3 weeks from today. I showed the email to Sarah that evening, and she laughed out loud. She has no idea what she is talking about, Sarah said. She worked as a paralegal at a small law firm downtown, and she had a much better grasp of legal hierarchies than Patricia apparently did. State law absolutely supersedes HOA bylaws. If your hedges are heritage plants, she cannot touch them. This is going to be amazing to watch. Dr. Martinez arrived right on time Monday morning, driving a green Department of Forestry truck. She was a short woman in her 60s with steel gray hair and the kind of competent, no-nonsense demeanor that made me trust her immediately. She spent nearly 2 hours examining my hedges, taking core samples, photographing them from every angle and reviewing all my documentation. Mr. Morrison, she said finally, standing back to look at the hedges with something like reverence. These are remarkable specimens. Based on the core samples and growth rings, I am dating these at approximately 90 years old. They are some of the finest examples of mature Gryslinia littorales in the Pacific Northwest. I am formally recommending them for heritage status, which will make them protected under ORS 215.720. That means no one, including your HOA, can require you to trim, remove, or significantly alter them without approval from the state. How long does the heritage status take to become official? I asked. The paperwork will take about 2 weeks to process. I will expedite it given your situation. You should have your official certificate and documentation within 10 business days. In the meantime, I am issuing a preliminary protection order effective immediately. Here, I will email you a copy right now. She pulled out her phone and typed rapidly. My phone pinged a moment later with a PDF attachment. The document, bearing the official seal of the Oregon Department of Forestry, declared my hedges to be under preliminary heritage protection pending final review. Thank you, I said, feeling a weight lift off my shoulders. This means everything. Thank me by taking good care of them, Dr. Martinez said with a smile. These hedges are a living link to Portland's horticultural history. They are worth protecting. After she left, I forwarded the preliminary protection order to Patricia with a brief message. As of today, my hedges are under state heritage protection. They cannot be trimmed or altered. I assume this resolves the violation notice. This time, her response took longer. 4 hours later, I received an email that was clearly written in anger, judging by the typos and caps lock usage. This changes nothing. The board has reviewed the matter and we do not recognize the validity of this so-called protection order. The bylaws are clear and you are in violation. Your hearing will proceed as scheduled, and if you do not comply with the board's ruling, fines will be assessed. This is your final warning. I stared at the email in disbelief. Sarah read it over my shoulder and let out a low whistle. She is actually going to do this, Sarah said. She is going to try to enforce HOA bylaws over state law. That is spectacularly stupid. What should I do? Show up to the hearing with your documentation and watch her dig her own grave. If she actually tries to fine you after that, you will have grounds for a lawsuit. Hell, the state might even get involved. The weeks leading up to the hearing were tense. I noticed Patricia driving past my house more frequently, sometimes stopping to take photos of my hedges. One evening, I saw her standing on the sidewalk with another board member, a man named Craig Phillips, both of them gesturing at my property and talking intently. When they noticed me watching from my window, they quickly walked away. I also started noticing subtle forms of harassment. My garbage cans, which I always carefully placed at the curb on collection day and retrieved promptly, were suddenly being cited for remaining at the curb past the allowable time, even when I had brought them in within hours of pickup. I received a violation notice for my mailbox being misaligned by approximately 2 inches from the approved angle. Another notice complained that I had parked my car on the street overnight, which was apparently only allowed for a maximum of 2 consecutive nights, and someone had documented my car there for 3 nights running, even though I had definitely parked it in my driveway on the second night. She is building a case to paint you as a problem resident, Sarah said when I showed her the accumulating violation notices. It is petty and transparent, but it is what people like her do when they feel like they are losing control. The official Heritage Protection Certificate arrived from the Oregon Department of Forestry exactly 10 business days after Dr. Martinez's visit. It was a beautiful document, printed on heavy paper with the state seal embossed at the top. It officially designated my Griselinia littoralis, hedges, as heritage vegetation under ORS 215.720 and outlined the protections they were now afforded. Any attempt to trim, remove, or significantly alter them without state approval would result in penalties including fines of up to $10,000 per violation. I had the certificate framed and hanging on my wall within a day. I also made multiple copies and prepared a presentation for the upcoming HOA hearing. If Patricia wanted a fight, I was going to come armed with facts. The night of the hearing arrived, and the community center was surprisingly packed. Apparently, word had gotten around the neighborhood about the dispute, and people were curious to see how it would play out. I recognized most of the faces, neighbors I waved to but did not know well. Some gave me encouraging nods as I took my seat in the front row. Others, mostly Patricia's friends, looked at me with varying degrees of disapproval. The HOA board sat at a long table at the front of the room. Patricia was in the center, flanked by Craig Phillips on her left and 3 other board members, Susan Yates, Michael Torres, and Jennifer Chen, who I realized with a start was Walter's daughter. I had met her briefly at the closing when I bought the house, but we had not stayed in touch. Patricia called the meeting to order with a sharp rap of her gavel. She went through some routine business first, approving the minutes from the last meeting and discussing a proposal to repaint the community mailbox kiosks. Then, she got to the main event. We now come to the matter of 847 Maple Ridge Drive and the violation of Section 7.3 regarding hedge height, Patricia announced, her voice carrying that particular tone of false professionalism that barely masked her eagerness. Mr. Yates Morrison, You have requested this hearing to contest the violation notice. You have 10 minutes to present your case. I stood up and walked to the front of the room, my folder of documents in hand. I had prepared for this, rehearsed it even, but my heart was still pounding. "Thank you for the opportunity to address the board," I began. "I am here tonight because I received a violation notice demanding that I trim my front hedges to 4 feet in height. However, there are several serious problems with this demand." I pulled out my first document and held it up. First, Section 7.3 of the bylaws, which is what the violation notice cited, does not actually specify a 4-foot height limit. It says hedges must be maintained at a reasonable height that does not obstruct sight lines or detract from aesthetic harmony. My hedges do neither. I have a corner lot with excellent visibility, and the hedges have been a distinctive feature of this property for 9 decades. Patricia started to interrupt, but I kept going. Second, and most importantly, these hedges are now officially designated as heritage vegetation under Oregon Revised Statute 215.720. I held up the framed certificate. The Oregon Department of Forestry conducted a formal assessment and determined that these Gricelinia littorale specimens, which are approximately 90 years old, qualify for heritage protection. This is not a request or a suggestion. This is state law. Any attempt to require me to trim or alter these hedges is not only invalid, it is illegal and subject to penalties of up to $10,000 per violation. The room had gone completely silent. I could see several board members shifting uncomfortably in their seats. Jennifer Chen was looking at the certificate with what appeared to be recognition and approval. "I have copies of the Heritage Protection Certificate, the relevant state statutes, and the preliminary protection order for each board member," I continued, passing out my prepared packets. "I am happy to answer any questions, but the bottom line is simple. State law supersedes HOA bylaws. These hedges cannot be trimmed without approval from the Oregon Department of Forestry, and that approval will not be granted because they are now protected heritage plants." I returned to my seat. Patricia's face had gone through several color changes during my presentation, settling finally on a shade of red that suggested her blood pressure was approaching dangerous levels. "This is absurd," she said, her voice tight. "The board does not recognize the validity of this certificate. We have our own landscaping standards, and they have been in place for 20 years. You do not get to just ignore them because you got some bureaucrat to rubber stamp your overgrown bushes." "With respect," I said, trying to keep my voice level, "it does not matter whether you recognize it or not. It is state law. You cannot opt out of state law because you do not like it." Craig Phillips leaned toward his microphone. "Mr. Morrison, surely you understand that when you purchased your home, you agreed to abide by the HOA covenants. Those are legally binding agreements. You cannot just wave a piece of paper and claim they do not apply to you." "The covenants are binding," I agreed, "but they are subordinate to state law. That is how legal hierarchy works. If the HOA bylaws said I had to paint my house bright orange, and then the city passed an ordinance banning orange houses, the city ordinance would supersede the HOA bylaws. This is the same principle." Jennifer Chen cleared her throat. "Patricia, if I may. I actually remember these hedges from when I was growing up. My father talked about them often. His grandfather planted them in 1934 as part of the original landscaping for the property. They are historically significant to this neighborhood. I think Mr. Morrison has a valid point about the heritage protection." Patricia shot her a look that could have melted steel. "We are not here to take a trip down memory lane, Jennifer. We are here to enforce the community standards that keep property values high and the neighborhood attractive." But if they are protected by state law, Michael Torres said hesitantly, then we cannot actually enforce the violation, can we? I mean, we would be breaking the law. We would be upholding our bylaws, Patricia insisted. The state has no business interfering with private property agreements. Actually, it does, Sarah said from the audience. She had not planned to speak, but I could see she could not help herself. I am a paralegal, and I can tell you with absolute certainty that state law supersedes HOA covenants. If you try to fine Mr. Morrison for not trimming protected heritage plants, you will be opening the HOA to significant legal liability. He could sue, the state could pursue penalties, and the HOA's insurance probably would not cover it because you would be knowingly violating state law. This is not open for public comment, Patricia snapped. Please sit down. Then let me make it official, Jennifer Chen said. I move that we dismiss the violation against Mr. Morrison based on the heritage protection status of his hedges. The state law is clear, and we have no legal standing to require him to trim plants that are protected by statute. I second that motion, Susan Yates said quickly. Patricia looked like she had been slapped. We have not finished deliberating. I have not even stated the board's position yet. The board's position does not matter if 3 of us vote to dismiss, Jennifer said calmly. That is how boards work, Patricia. We vote. So let us vote. All in favor of dismissing the violation, Jennifer, Susan, and Michael all raised their hands. Patricia and Craig sat with their arms crossed, but it did not matter. 3 votes out of 5 was a clear majority. The motion passes, Jennifer announced. The violation is dismissed. Mr. Morrison, you are free to maintain your hedges as you see fit, in accordance with state heritage protection guidelines. The room erupted in scattered applause. I felt a wave of relief wash over me so intense that I had to sit down. Sarah squeezed my hand. Patricia slammed her gavel down repeatedly, her face now approaching purple. This meeting is adjourned, she barked, gathering her papers with sharp, angry movements. As people filed out of the community center, several neighbors came up to congratulate me. An older woman named Margaret, who lived 3 houses down, told me she had always loved my hedges and was glad they would be preserved. A younger couple thanked me for standing up to Patricia, who they said had been making everyone's lives miserable with petty violations. Jennifer Chen approached me as I was leaving. Mr. Morrison, I wanted to apologize for not reaching out sooner. When I heard about the violation notice, I should have said something right away. Those hedges meant a lot to my father. He would be happy to know they are being protected. Thank you for your vote tonight, I said. It means a lot to have someone on the board who understands the history. Patricia is not going to let this go, Jennifer warned. She does not handle losing well, just be careful. She was right to warn me. 2 days after the hearing, I found a new violation notice in my mailbox. This one claimed that my hedges, while they might not need to be trimmed, were insufficiently maintained and showed signs of neglect and improper care. It demanded that I provide evidence of a professional maintenance plan within 7 days or face fines. I could not believe what I was reading. The hedges looked exactly as they had looked during Dr. Martinez's assessment. They were healthy, well-formed, and carefully maintained. This was purely retaliatory, and it was not even subtle about it. I called Dr. Martinez to ask her opinion. She sighed heavily when I read her the new violation notice. Mr. Morrison, this is harassment. Your hedges are in excellent condition. I documented that thoroughly in my assessment. If your HOA president is trying to claim otherwise, she is lying. I can provide you with a written statement to that effect if you need it. I think I am going to need it, I said, and probably a lawyer too. Sarah's law firm did not handle HOA disputes, but her boss recommended someone who did. That is how I ended up in the office of Rachel Winters, an attorney who specialized in HOA law and had a reputation for eating board presidents like Patricia for breakfast. Rachel was in her 40s, dressed in a sharp gray suit, and she listened to my story with the kind of focused intensity that made me feel like she was already building a case in her head. "Here is what is happening," Rachel said when I finished. "Your HOA president is engaged in targeted harassment because you embarrassed her at a public meeting. The new violation notice is retaliatory and without merit. We are going to respond with a cease and desist letter, and if she does not back off, we are going to file a lawsuit for harassment and intentional infliction of emotional distress." "Will that work?" I asked. "It will work, or it will make her dig herself in deeper, at which point we will have an even stronger case. Either way, you win. But I need to be honest with you. This could get expensive if it goes to court. People like Patricia often double down rather than admit they are wrong." "How expensive?" "Potentially tens of thousands in legal fees. Although if we win, which I am confident we would, we can pursue damages and attorney fees from the HOA. The HOA's insurance would probably end up covering most of it, and Patricia herself could be held personally liable for acting outside her authority." I thought about the cost and stress of a lawsuit. Then I thought about Patricia's smug face at that first meeting, her willingness to ignore state law, and the way she had immediately tried to retaliate after losing the vote. "Send the cease and desist," I said. Rachel drafted a letter that was a thing of beauty. It laid out the timeline of events, cited the relevant case law on HOA harassment and retaliation, quoted Dr. Martinez's assessment of my Hedges' excellent condition, and made it crystal clear that any further violations or fines would result in immediate legal action. She sent it via certified mail to Patricia personally and to the HOA board as a whole. Patricia's response came not through official channels, but through the neighborhood gossip network. According to Margaret, who seemed to know everything that happened in our community, Patricia was telling everyone that I was a troublemaker who thought I was above the rules, and that she was going to make sure I regretted moving into Meadowbrook Estates. True to form, Patricia did not back down. Instead, she escalated. I received another violation notice, this one claiming that the root system of my hedges was encroaching on the community common area and causing damage to the sidewalk. The notice demanded that I either remove the hedges entirely or install a root barrier system at my expense, estimated at $15,000. I walked the entire perimeter of my property, examining the sidewalk carefully. There were a few minor cracks, the kind you would find on any sidewalk in any neighborhood in Portland. None of them were anywhere near my hedges, and certainly none of them showed signs of root damage. I took extensive photos and measurements. When I sent the new violation notice to Rachel, I could practically hear her grinning over the phone. "She just handed us our case on a silver platter," Rachel said. "She is now claiming your hedges are causing damage that does not exist and demanding you remove protected heritage plants. That is not harassment, that is potentially criminal. We are filing suit tomorrow." The lawsuit hit the HOA like a bomb. Rachel filed in Multnomah County Circuit Court, naming both the Meadowbrook Estates HOA and Patricia Hendricks personally as defendants. The complaint alleged harassment, retaliation, intentional infliction of emotional distress, and attempted destruction of protected heritage vegetation in violation of state law. We were asking for damages, attorney fees, and an injunction preventing the HOA from issuing any further violations related to my hedges. Within days, the story hit the local news. A reporter from the Oregonian called me for an interview, and I spent an hour explaining the situation. The article that ran the following week was headlined, "HOA President Allegedly Harassed Homeowner Over Protected Heritage Plants," and included quotes from Dr. Martinez about the rarity and significance of my hedges. It made Patricia look exactly as unreasonable as she was. The publicity changed everything. Suddenly, I was getting calls and messages from other residents in Meadowbrook Estates who had their own stories of Patricia's abuses of power. A man named Robert told me Patricia had fined him $3,000 for painting his front door a shade of blue that was supposedly not on the approved color list, even though he had the paint chip to prove it was. A woman named Lisa said Patricia had tried to force her to remove a wheelchair ramp she had installed for her disabled mother, claiming it violated aesthetic standards. The stories kept coming, and they painted a picture of a petty tyrant who had been abusing her position for years. Rachel was delighted. "This is perfect. We can potentially turn this into a class action. If enough people have been victimized by her harassment, we can go after her and the board for a pattern of abuse." But before we could pursue that angle, something unexpected happened. I received a call from Michael Torres, one of the board members who had voted to dismiss my original violation. "Mr. Morrison, I need to talk to you," he said, his voice urgent. "Can we meet somewhere private?" We met at a coffee shop in downtown Portland. Michael looked nervous, constantly glancing around as if worried someone might see us together. "I am resigning from the HOA board," he said without preamble, "and I think you should know what is really going on. Patricia has been running the HOA like her personal fiefdom for 3 years. She has a file cabinet in her garage full of violation notices she has issued, and I think a lot of them are fraudulent or exaggerated. She targets people she does not like and makes their lives hell until they either comply or move. Why are you telling me this?" "Because it is wrong, and because I think you are actually going to do something about it. Jennifer Chen is also resigning. We have both had enough. Susan Yates wants to resign too, but she is scared of retaliation. That leaves just Patricia and Craig, which is not enough for a quorum. The board is basically going to collapse. You have proof of what she has been doing." Michael hesitated, then reached into his bag and pulled out a flash drive. "This has copies of emails and documents from the past 2 years. Not everything, but enough to show a pattern. I am giving this to you because I think your lawyer can use it. I just ask that you keep my name out of it if possible." I took the flash drive with shaking hands. "Thank you. This could make all the difference." Rachel nearly fell out of her chair when I showed her what was on the flash drive. There were hundreds of documents. Emails where Patricia discussed targeting specific homeowners for violations. Spreadsheets tracking fines and fees that looked suspiciously like they were being used to pad the HOA's budget. And even notes about which residents had political yard signs Patricia disagreed with, followed by increased violation notices to those homes. "This is not just harassment," Rachel said, scrolling through the files. "This is conspiracy, fraud, and possibly embezzlement if she has been collecting fines that were not legitimate. We need to bring this to the attention of the Oregon Attorney General's office. This is beyond a civil lawsuit now." The next few weeks were a whirlwind. Rachel contacted the Oregon Department of Justice, and they opened an investigation into the Meadowbrook Estates, HOA, and Patricia Hendricks personally. The Oregonian ran a follow-up story based on the leaked documents, and suddenly, our quiet neighborhood dispute was a major local scandal. News crews showed up in Meadowbrook Estates, interviewing residents and filming Patricia's house. Patricia went into hiding, refusing to answer her door or respond to interview requests. Craig Phillips issued a statement saying the allegations were false and politically motivated, but he resigned from the board 2 days later. The HOA effectively ceased to function, which was both a relief and a problem. Since there were actually some legitimate community services the HOA was supposed to provide, like maintaining the common areas and the entrance gate. A group of residents, led by Jennifer Chen and Margaret, formed an interim committee to handle essential HOA functions while the legal mess got sorted out. I joined the committee, partly because I felt responsible for blowing everything up and partly because I wanted to make sure the HOA was rebuilt into something fair and transparent. The investigation took 3 months. During that time, I learned more about HOA law and Oregon nonprofit regulations than I ever wanted to know. It turned out that Patricia had been doing something even worse than we had initially thought. She had been collecting fines from residents and depositing them into a separate bank account that was not part of the HOA's official books. Over 3 years, she had collected more than $60,000 in questionable fines and fees, and only about half of that money had ever made it into the HOA's official accounts. The rest had simply disappeared. When the Attorney General's office presented their findings, they referred the case to the Multnomah County District Attorney for criminal prosecution. Patricia was charged with theft in the first degree, criminal misconduct, and multiple counts of fraud. Craig Phillips was charged as an accessory after the fact, since he had known about the separate bank account and helped Patricia conceal it. The criminal trial took place in October, nearly 8 months after that first violation notice had arrived in my mailbox. I was called as a witness, and I spent 2 hours on the stand describing the harassment and retaliation I had experienced. Other residents testified too, telling stories of fines and violations that had no basis in the actual bylaws. The most damning testimony came from a forensic accountant who had traced the missing funds and shown exactly how Patricia had been skimming money from the HOA. The jury deliberated for less than 4 hours. Patricia was found guilty on all counts. Craig was found guilty of accessory charges. At sentencing 2 weeks later, Patricia received 3 years in prison and was ordered to pay full restitution of the stolen funds plus penalties. Craig got 2 years of probation and community service. I sat in the courtroom as the judge read the sentences, and I felt a complicated mix of emotions. I had never set out to destroy anyone's life. I just wanted to keep my hedges and live in peace. But Patricia's actions had forced this confrontation, and ultimately, justice had been served. The civil lawsuit was settled out of court. The HOA's insurance company, faced with overwhelming evidence of wrongdoing, agreed to pay damages to everyone who had been targeted by Patricia's harassment. I received $45,000, which more than covered my attorney fees and compensated me for the stress and aggravation. More importantly, the settlement included an agreement that the HOA bylaws would be completely rewritten with input from all residents, and that no board member could serve more than 2 consecutive terms as president. The new HOA board, elected in a special vote, included Jennifer Chen as president. One of their first acts was to pass a resolution officially recognizing my hedges as a historic landmark and neighborhood treasure. They even installed a small plaque on the sidewalk in front of my house, describing the history of the Gricelinea Little Raleigh's hedges and their heritage protection status. Sarah and I got married the following spring. We held the ceremony in our backyard, with the ancient hedges forming a magnificent green backdrop. Dr. Martinez came as a guest, along with Rachel Winters and many of the neighbors who had supported me through the ordeal. Jennifer Chen gave a toast about the importance of standing up for what is right, even when it is difficult. Patricia's house, which had sat empty during her trial and incarceration, was eventually sold. The new owners were a young couple with 2 small children who seemed delighted to be part of a neighborhood that had learned hard lessons about accountability and fairness. They introduced themselves to me within a week of moving in, and we became friendly in the casual way of good neighbors. My hedges continued to thrive, their silvery green leaves catching the morning light just as they had for 90 years. I maintained them carefully, following Dr. Martinez's recommendations for preserving heritage plants. They remained the tallest hedges in the neighborhood, and now nobody would ever suggest otherwise. Looking back on those 8 months of conflict and drama, I sometimes wondered what would have happened if I had just trimmed the hedges when Patricia first demanded it. I would have saved myself stress, legal fees, and countless hours of meetings and court appearances. But I also would have destroyed something irreplaceable and allowed a petty tyrant to continue abusing her power. Standing up to Patricia had been the right choice, even though it had been much harder than I expected. The Meadowbrook Estates Homeowners Association became something different after the scandal. Meetings were actually well attended now, with residents actively participating instead of leaving everything to the board. The bylaws were simplified and made more reasonable. A new rule required any violation notice to be reviewed and approved by at least 3 board members before being issued, preventing any single person from using violations as a weapon. Fines were capped at reasonable amounts and could only be assessed after proper due process. Other HOAs in Portland started contacting us to learn about our reforms. Jennifer Chen and I even spoke at a conference about HOA governance, telling our story as a cautionary tale about what happens when boards lose sight of their purpose and focus on control instead of community. The presentation was well received, and several HOAs adopted similar reforms to prevent their own Patricia Hendricks situations. As for Patricia herself, I heard through the neighborhood grapevine that she was released from prison after serving 18 months of her 3-year sentence. She moved somewhere out of state, possibly to live with relatives. I never saw her again, and honestly, I was fine with that. I did not hate her, despite everything she had put me through. I mostly felt sad that she had thrown away so much over something as pointless as power and control in a homeowners association. My career as an environmental consultant took an interesting turn after the Hedge controversy. The publicity from the case led to several clients hiring me specifically to help them identify and protect heritage vegetation on their properties. I became something of a local expert on Oregon's heritage plant protection laws, and I even worked with the state legislature on a bill to strengthen those protections and make them easier for property owners to access. The bill passed unanimously, and I was invited to the signing ceremony at the state capitol. Sarah and I eventually started a family, and our daughter Emma loved playing in the yard beneath the towering hedges. When she was old enough to understand, I told her the story of how these plants had been the center of a legal battle that changed our neighborhood. She thought it was the coolest thing ever that her house had a historic landmark in the front yard. The plaque the HOA had installed became a minor tourist attraction. People interested in urban forestry and heritage plants would occasionally stop by to look at the hedges and take photos. I always made a point of going out to talk to them if I was home, sharing the history and encouraging them to look for and protect heritage vegetation in their own communities. Dr. Martinez told me that inquiries to the Heritage Tree Program increased significantly after our story made the news, which meant other historic plants were being identified and protected. Years later, I served a term as president of the Meadowbrook Estates, HOA. something I never would have imagined when I first moved to the neighborhood. Under my leadership, we established a community garden, organized neighborhood cleanup events, and created a grant program to help residents restore historic features of their homes and landscapes. The HOA became something positive, something that actually added value to people's lives, instead of making them miserable with petty rules and violations. The Hedges, those magnificent Griselinia litorale specimens that started everything, continued to stand tall and proud at the corner of my property. They had witnessed 9 decades of Portland history, from the Depression era when they were first planted through wars and recessions and social changes. They had survived Patricia's attempt to destroy them, and with their heritage protection status, they would survive for many decades to come. Sometimes on quiet mornings, I would stand in my driveway with my coffee, looking at those hedges and marveling at how something so simple had led to such dramatic consequences. A demand to trim some bushes had exposed corruption, ended a reign of neighborhood tyranny, sent someone to prison, and ultimately made our community stronger and better. It was a reminder that standing up for what is right matters, even when the issue seems small. The Heritage Protection Certificate hung on my wall, a reminder of that turbulent period and its eventual resolution. Visitors always asked about it, and I was always happy to tell the story. It had become part of my identity in a way. I was the guy who had stood up to his HOA and won, the guy who protected the historic hedges, the guy who accidentally exposed massive fraud and sent a corrupt board president to prison. But more than any of that, I was just a man who loved his home and wanted to preserve a piece of living history. The fact that doing so had required lawyers and lawsuits and criminal investigations was almost beside the point. The hedges had been worth fighting for, and I had fought. That was enough. As I stood there in my driveway on a clear Portland morning, the sun rising over my protected heritage hedges, I felt a deep sense of satisfaction. My property was my own, maintained according to my choices and state law rather than the whims of a petty tyrant. My neighborhood was governed fairly and transparently, and those magnificent silvery green hedges would stand for another 90 years, a living testament to the importance of protecting our natural and historical heritage. The legal documents were filed away, the court appearances were over, and Patricia was out of our lives. The drama had ended not with a bang but with a quiet mourning and the rustle of 90-year-old leaves in the Oregon breeze. Justice had been served, heritage had been protected, and community had been restored. In the end, that was all I had really wanted. That, and to keep my hedges exactly as they were, tall and magnificent and protected by law, standing guard over my corner lot for generations to come.